Hi, and welcome to the Grand Plans podcast. I'm Susanna Barton. I'm the founder of the Grand Plans online community and a new website. Yes, I made it by myself. It's at www.mygrandplans.com. And today we are talking about all things legal with Kent Sausaman, who is a lawyer with Frazier and Frazier Attorneys at Law, PA, here in Jacksonville, Florida. So Kent, welcome to the Fifths Production Studio. We're so glad to have you here today.
I'm honored to be here. Thank you for having me.
Yeah, in full disclosure, Kent recently redid our will, mine and David's. So Kent, I thought, well, for talking to him, like, oh, he's the guy. We got to get him into the studio to talk about grand plans and older people stuff, because not only do you know your stuff, but you also have a great radio voice. And I think I told you that at the time, but I was like, okay, it's happening. So,
that's right. And a face for radio.
Yeah, no, a voice for radio. So anyway, why don't we just go ahead and start right there with the wills? I mean, what I want to do in this 30 minutes is talk about all of the documents that people will need before they die to make sure that they're well prepared, or better yet, that their loved ones are not left holding the bag or, in a crazed state. So we'll talk about those important documents, and let's kick it off with the will. And that's so important, and I'm sure why a lot of people, one of the first things people come to you about. So let's talk wills.
Sure. In Florida, if you want to have a will, I think principally to express your intentions on, who you want to be in control of managing your affairs after you pass away, and express your intention on who you want to benefit with your assets following your passing. So that's the principal purpose of the will, is to outline those intentions. And in connection with the will, we want to make sure that the assets that you own are teed up, for lack of a better word, to follow the will instructions. And so, because in the state of Florida, as in every other state, the assets will pass. The assets that you own in your individual name are only the assets that are going to pass under your will. So, for example, if you have a joint checking account with your spouse in Florida, that asset is not going to be governed by your will. It'll pass to the surviving spouse if they're jointly owned. If you have a retirement account or a life insurance policy or another asset that has a beneficiary designation on it, well, the beneficiary designation will control, not the will. So in addition to drafting a document to express your intentions, that's maybe 1A. A 1B item priority is to make sure that we've identified the assets, to make sure that they are going to also pass with the same intentions of the will, or have them be governed by the will. So it's express your intentions in the written document, but then also make sure that we align the asset titling or beneficiary designation to align with what the will provides and what the intentions are.
And what happens if there is not a will, and how does that, and can you talk a little bit about probate also and how that relates? I just went through it in Texas with my father, who passed away 2 years ago, and my brother was the executor. It did go to probate it wasn't as long, and what didn't take as long as we thought it would. But anyway, can you talk about the little ins and outs of that?
Sure. So in Florida, as in every other state, there's something that's called the intestacy statute.
Okay.
And so what that is the legislature of the states has written a will for you, but they have taken the liberties of, what they've expressed what they think most people would want their will to say. So in Florida, just for example, if you pass away and you're survived by a spouse and children of that marriage with that spouse, then everything passes to the surviving spouse. And if there is no surviving spouse, it goes equally among your children.
And that's if you don't have a will in place.
That's right. That's the will the legislature has written for you. Now it gets a little more complicated if you have a blended family situation. So children that are not the children of your spouse, in that instance, then the spouse would get 50%. And the children would get 50%.
Oh, okay.
And Florida's got some very unique homestead rules, so everybody's familiar with the homestead tax exemption. There's actually three kind of legal homestead rules. One is the homestead tax exemption, which everybody benefits from on an annual basis when they get the property tax bill in early November. There's also some constitutional protections with respect to protecting your home against creditors. So as a general rule, outside of a bankruptcy context, which can complicate things a little bit, if somebody sues you, you get an accident, a business deal, what have you, your home is your safest asset. They can't force the sale of your home to satisfy a judgment creditor. Now, obviously, if you don't pay your mortgage, your property taxes, or pay the contractor who put the new roof on, there's certain things that liens that can be enforced. But anyway, the third component of the homestead is that there are restrictions on who you can leave your homestead to. So if you have a spouse or minor children, essentially the Florida Constitution says that you can't leave your wife and kids out to dry and give your house to somebody else. And so there's restrictions there.
That's nice. That's nice of the state to do that.
That works out. Now it can create some issues in the context of if you have maybe a blended family situation and minor children. Then there can be some issues about, where you leave your house, and some restrictions on that. That's probably too much in the weeds of these things, but these are considerations to have. So sometimes those rules can interplay with the statutes in the intestacy statutes to disrupt some of that intent. But what will happen is, so whether you have a will or you utilize the will that the legislature has written for you, the probate process is really the way I've tried to describe it in the last couple of years. It's kind of come to me. I always try to make these things as simple as possible.
Yeah. It's confusing. I mean,
it can be.
Lot. Yeah.
The probate is really the way that assets that an individual owns in his or her individual name passes to the heirs of their estate, the beneficiaries. So probate, if I have a bank account at Bank of America or Wells Fargo or whatever the banking institution is, and I die, I don't have a beneficiary designation on the account, or I don't have my spouse is not listed on the account. Well, once I pass away, there's nobody who's authorized to access the account. My wife can go in and say, I'm Kent's wife, and I need access to the account to, pay the kids' tuition or whatever the case may be. They're going to say, sorry, ma'am, you're not on the account. We're not going to give you access to it. We're not going to give you information. So what the probate process is whether it's the person who's appointed as the executor. In Florida, we call it a personal representative.
And everyone who has a will has an executor. Is that correct? Or has named an executor, hopefully?
Yes. Well, hopefully the attorney who has prepared your will has, in addition to, stating where your assets go, that's a critical part of the will, is to name an executor. Another critical element, just as while we're talking about this, is if you do have minor children, there should be a provision in there that appoints a guardian. So somebody that would take care of your children, potentially their property, but certainly be the caretaker, for lack of a better word, for the children. You want to designate who your preference is in that will, because if that situation comes to fruition where both the parents have passed away, the judge will certainly give preference and deference to the individual or individuals who you've named as the guardian for your minor children. And so the the personal representative. So the probate process is really a matter of, I think a lot of people are familiar with the idea of a power of attorney. You name somebody to step in while you're living to, and I'm coming back to the personal representative, and this is kind of a roundabout way of describing it, I hope that fairly simply, but a personal representative is really your post-mortem power of attorney.
Are you saying a personal representative meaning executor?
Executor,
okay,
yeah. So we use those terms interchangeably.
Okay.
Some states, the statutes refer to an
Right.
executor or an executrix if it's a female. But in Florida, we use the term personal representative. So they're one and the same.
Okay.
And so the personal representative is somebody who's named in your will, or if you don't have a will, there's a preference to the appointment to that position in the statute. So first is your wife or your spouse, I should say, and then it goes to, who's closest in relation to you among other family members and things like that. And so that person, the probate process really gets kicked off by if somebody has an asset in their individual name and a survivor, the spouse or whoever the beneficiaries are can't get access to them, then the judge will appoint somebody as the personal representative or the executor, and that's either the person named in the will or the person who fits the closest priority in statute. And then we'll give this person we call them letters of administration in Florida. Some places call them letters testamentary. But anyway, that in effect is your post-mortem power of attorney that allows the person to take that court order, is really what it is, to the bank and say, I'm in charge of the estate.
Right.
And I can now get my hands on those dollars that are in this bank account or this asset, or give somebody the power to sell real estate that's in a deceased person's name. And without getting into all of and we can talk a little bit more about some probate details, but without getting into all the details, in exchange for the judge giving the personal representative this post-mortem power of attorney, which grants the personal representative pretty broad powers to access the money and the other assets of a decedent, the court will require that personal representative report back to the court about what assets have come into their possession and provide proof that they have notified all of the interested persons involved in the estate. So that can be, the surviving spouse, the beneficiaries listed in the will, creditors of the estate, making sure that any, creditor situations get smoked out pretty quickly. And there's some procedures that have to do with, notifying creditors that you're aware of, and they have a fairly short 30-day period of time to respond and say, okay, well, here's what you owe us. Let's settle this out. And then for, other creditors who may not be, reasonably ascertainable through check in the mail or getting access to email or whatnot, there's a procedure to publish notice in the local newspaper and notify the creditors. So this process of reporting back to the judge that I've come into possession of these assets, I've notified these people, and then we have the beneficiaries or the creditors sign a waiver form, or at least acknowledge that they're okay with moving forward. And so it's this kind of reporting back to the court to make sure that that everything has been done and that there's no issues, and the court gives creditors or beneficiaries who may be disgruntled with one thing or another.
How long does it take, or what's the timeline people should expect for
a probate
situation?
Yeah, so by definition, by statute, really, because there is this 3-month creditor period, it's going to be at least 3 months.
Okay.
And so typically by the time we get through that 3-month period, there's some orders usually related to the homestead property about getting it transferred to family members that the judges are all a little different in the way they do things, but oftentimes they want to wait until this 30-day creditor period has passed before they do, anything, sign any orders related to the house. So in the fastest, most efficient probate where there's no creditors and we've got a couple of assets, it can take as little as maybe 90 to 100, at least 90, but 120 days maybe, and that's not after the death. That's 90 days from the time we've asked the judge for this post-mortem power of attorney, and actually begun the process of gathering the assets and notifying the right people. Now in Florida there's a short form, and we can kind of talk about maybe a revocable trust as an estate planning option. Which
is there a way to avoid probate, or is that's I would think
right? So that's where we're headed. That's right.
Yeah.
So avoiding the probate is one thing that a lot of people find. It's appealing. It's a little more efficient from the standpoint that we don't automatically have to go to court and request that the judge provide us with this post-mortem power of attorney and then report back to the court. And essentially the way that happens is you don't die with assets titled in your individual name.
Do you advise your clients that that's the way to go?
More often than not.
Practice?
Yeah, more often than not. That's correct. There are some situations. So, for example, young people who are in accumulation mode, and they're and the likelihood of them not having all of their assets titled correctly after they leave we do the best we can to get everything titled right. But then if I don't know about them acquiring an asset, or they don't acquire it correctly in the future in the name of a trust or however we set it up, then they may have the trust and have everything will be teed up perfectly when they leave my office or shortly thereafter. But then a year from now, they open a new bank account or acquire a new asset or start a new company, and they don't get it titled correctly. And then we're back in the probate situation with respect to that one asset. Right. But to get out of the probate, the simplest way of probate avoidance is, if you and your spouse own an asset together, it just passes. If one spouse dies, it just passes automatically to the surviving spouse. Well, now that surviving spouse has an issue, right? Because he or she may own that asset in their individual name. So what the revocable trust is a trust that you create for yourself. You're the creator. You are the beneficiary of the trust. So, and then you put assets into the trust, and it'll say during my lifetime I can use the assets however I want. My relationship to the assets don't change one bit. The trust's tax ID number is my social security number, so there's no additional tax filings or anything like that. The trust is totally invisible from a practical standpoint and with respect to your relationship with the assets or tax filings. But you don't own the asset in your individual name. You own it you put your trustee hat on.
It's magic.
And so what happens is you what you will name in the trust agreement a successor trustee or multiple successor trustees, and those are spelled out in the trust instrument. So if there is an event which renders you incapable of being the trustee, whether it be an incapacity event, dementia, Alzheimer's, what have you, or you resign, for example, or you pass away, then the next in line trustees step up. And in a perfect world where all the assets are titled in the name of the trust, then that trustee, following the death or incapacity event, will take proof of the incapacity, a doctor's note or something like that.
I will just interrupt for a second
Please.
And say from experience that can get a little dicey. I was the replacement trustee or whatever for a couple who both had issues where they were incapacitated, and it was much different proving that with implementing a power of attorney for them than it was getting in as the trustee. They needed help selling their home and some things that were in the name of the trust, and it's like, oh man, I can't even get them out of the house, much less to see two doctors who, it's
right.
just it's a little different. So
right.
I just add that because it can get complicated.
That's right. Yeah, and so in our documents, one of the things we have is the definition of incapacity is a doctor's note. Two doctor's notes, so that way that
as a trustee,
to be incapacitated, to be forced to step away.
Right.
So
that's hard.
But a lot of times, if somebody is, one thing, and again, it's not a one-size-fit-all situation, but, I would say a decent amount of time, the backup trustee is somebody who's close to the initial creator of the trust or the person who is needing a little bit more hands-on from friends and family members. And so, a lot of times what we can do is, if the person is not, totally incapacitated from a legal sense, meaning, that they know who they are, they know what they have, they knew what their documents say. So
it's a good practice to actually tell the person, because this did not happen that way with me. It occurred to me after looking through some documents that they had named me in these various roles. So that was a surprise.
Yeah. So
it was not fun.
Yeah. So I think that transparency in these matters helps.
Yes.
But I will tell you that, and you probably have come across people who are very private individuals, and who don't have any desire to, even though they've named you as their backup trustee, or maybe even you're the agent under the power of attorney. They keep that very, very close to the vest. For just their personal purposes or their personal reasons. So, and one of the things that you can do is, depending on the relationship and how trusting they are, obviously they trust you. If they're going to name you as a trustee, they trust you. Do they trust you to handle things alongside them while they're living? There can be multiple trustees of the trust. So a person can name himself or herself and maybe a child.
Can you name a professional trustee? Is there such thing?
Yes.
Like a bank or like Merrill Lynch or something? Sure.
Yeah, absolutely. So there are, Bank of America, Wells Fargo, all of the big banks have trust companies built into them, or trust departments.
Right.
There are a lot of smaller banking and trust companies, and then there's a lot of and then there's obviously professionals, lawyers. Often, we from time to time, as the need arises, can step in and fill that role.
But that is costly. I mean, that's costing. You're not doing, if you're the trustee, you're not just doing it to be nice. You're doing it.
We are hired to. We are hired to render professional services.
Right.
And one thing that that we try to avoid doing, and which is out there for is that the individual lawyer technically can charge legal fees and charge trustees fees. Effectively, some may argue double dipping. So in today's world, as of relatively recently, the last couple of years, there is in Florida, if you want to get fees for being a trustee or a personal representative, as a lawyer, you have to make certain disclosures regarding that ability, and the clients have to sign off on it. So, in my office, if you name me as a trustee, you're gonna sign a 2-page thing where I tell you that we're able to charge these fees, and we try to be transparent and not double dip, and make sure that we're only charging for legal services and not trustee services on top of that, assuming that the facts, and if there's some issue with litigation or family politics and drama that spills over into obviously that's more time and higher fees and things like that. But we try to be reasonable and be there as a an asset for our clients in the event that we need that to happen. And a lot of family members serve without children will serve without.
Find somebody you trust.
Yeah, and a lot of times the kids will serve without wanting to charge a fee.
Right. But you can.
You can, yeah. So any trustee or personal representative, be it your child, family member, a professional, they're entitled to reasonable compensation. There's a fee schedule in the Florida Probate Code that spells out what reasonable compensation is, and it's it's like 3% on the first $1 million in assets, and then the percentage goes down as the dollar of the value of the estate goes up, and there's a comparable but less the fee schedule is for in the Florida Trust Code for handling a revocable trust for a trustee is 75% of the probate code statute, but a lot of trustees will, keep their time and not bill on a statutory fee schedule based on a percentage of assets. They'll bill their time, and that's whether it's banks usually have their own fee schedules that they work on, and there's a lot of in today's world, the way that just the trust business has just changed over time is now there's more. What we call administrative trustees. So a trust company that's not a bank, and they handle all the administrative work. They do the accountings, but there'll be an individual trustee and a corporate trustee. But the corporate trustee is kind of handling the paper pushing and doing the accountings and distributing stuff out and helping with the money. And then you got a financial advisor involved managing the assets. And then you've got an individual
in the kitchen.
And then you got an individual trustee, kind of a family member perhaps, that's helping to manage the politics of the beneficiaries and all that kind of stuff. So,
all right. So for time, I want to make sure that we get to talking about quickly power of attorney documents, what the other essentials are. And I'm guessing there are power of attorney, any kind of medical directives, because this legal piece, it's important when you're, in this room, when we're having conversations, it kind of the core of it is the financial piece, the health piece, the medical piece, and then of course the legal piece, and that's why we're here. So let's wrap up talking about the other essentials beyond the will. Once the will's all done, you got that squared away, what's next?
So the three things that anybody that comes into my office will leave with is obviously the will that we've discussed. You'll have a power of attorney, a durable power of attorney. It's important to have a durable power of attorney. If you just have a general a general power of attorney, it is automatically revoked when you become incapacitated.
Oh, okay.
Because the legal idea is that once you lose capacity, you can no longer consent. And so a durable power.
So what happens then if you have a general power of attorney and
it expires essentially or is ineffective? Well, then you're in a guardianship situation.
Oh no, that's horrible. That's what no one wants.
Well, and we'll come back to that in one second. Let me answer your first question about
durable.
We got the durable power of attorney, which the durable piece of it means that it will continue to be in effect after you are incapacitated,
but not after you die.
It terminates when you die.
Yeah.
And so hence the idea about the personal representative needing a postmortem power of attorney.
Yes.
And so, but the power of attorney is an instrument whereby you're authorizing somebody else to act on your behalf. Now, I'm sure a lot of people, unfortunately, have had some issues with trying to actually use a power of attorney.
Yes, it's horrible. I'm here to tell you, it is not fun. This happened to me again, and it's, I would actually advise no one to do it. I'm just kidding. I think everyone probably will have to do that at some point in their life, but it's not easy.
It's particularly with banks, they are
credit cards.
Yeah, they are.
All that.
Financial institutions are hesitant and I think concerned about liability issues because of power. If anybody reads a power of attorney, you are giving somebody the right to do everything possible for you. Sell your house, sell your car, access your bank accounts, everything that you could possibly do as an individual. From a financial perspective, you're granting somebody else that authority, and so
you have to have access to fax machines and rotary phones and all the other archaic communication.
So there's some procedures in the Florida statutes that in the last decade. I mean, it used to be we no longer in Florida can you have something called the springing power of attorney, which is the power of attorney is dormant and only becomes effective upon an incapacity event. Well, not only do people have concerns about the powers of attorney, the powers granted in the power of attorney, but how is a bank supposed to know whether a person's incapacitated, not incapacitated?
Right.
So the springing power of attorney is gone with the wind as of about 2011. And so now you just have these concerns. So there's a procedure if the bank is going to reject a power of attorney or not, give it the authority that it should have. There's a procedure. They have to, they have to send you a letter, state exactly why, and all that stuff. So typically, we have these situations where, after the client goes to the bank and then I come back and, somebody will, I get a phone call from the client at the bank and then we're talking to the banker. And so eventually, usually it works out okay, but it kind of disrupts the scheduling of your afternoon because you end up fighting with the banker for a little bit.
Right,
but
that's why you have a good lawyer.
That's right. And hopefully you can get to somebody who can make some decisions at the bank and get it run up the food chain to their legal department and get it going pretty quick. But it's important to have that because you never know. For example, if you're, there's a lot of situations where you can be incapacitated but not killed.
Right.
I mean, you could be, you could be in a car accident and, be in, in the hospital for a period of time and not being able to handle things. And so, should you have a situation come up, maybe you're about to close on a house or sell a property or something like that. If you're a real estate person or a principal residence, and you might need your wife to sign for you, or your husband to sign for you in that instance. So it's important to have that document because there's a lot of very foreseeable instances where you could be unavailable for one reason or another and need somebody else to handle that for you. And then in addition to the power of attorney, the third document and I see it done a couple different ways. We use a single document. Other firms break these two out into separate documents, but it's a living will and a designation of healthcare surrogate form.
Yes.
And the designation of healthcare surrogate form is essentially giving, like the power of attorney, authorizing one or more persons to make medical decisions for you, to provide informed consent to medical institutions, if you need to have a procedure.
Is that in conjunction with a medical directive? And is the medical directive a legal document, or is it?
Yeah, exactly. Yeah, so so there's a designation of a healthcare surrogate where you're authorizing somebody else to make medical decisions for you. Then there is a living will, which is not. It's more of a declaration as to your wishes under certain circumstances, as opposed to you appointing a person to be your to make decisions for you. So, for example, I was probably in high school, but there was the case of, I think she was down in Terry Schiavo.
Yes, I remember
very,
that.
Very newsworthy. I went up to the Supreme Court, but in essence, she had she was in a coma. She was, I think, in a persistent vegetative state, or more or less brain dead, and they were keeping her alive artificially, life support, what have you. And so, and there was a debate as to whether or not they should, remove life-sustaining measures and let her pass, or keep her alive. And there was a debate between the husband and the parents about conflicting testimony. And anyway, it was national news, and it was a big drama.
But we have that outcome to thank, I would imagine.
Well, yeah, and these
options.
Yeah, and those had she had certain documents in place that had expressed her intentions, then they could have saved themselves a lot of that dramatic situation as it played out. But the living will document says that if you're, there's got to be three things that happen, and this is just taken straight from the Florida statutes. So the Florida statutes provide a form, living will, that says if you're, number one, incapacitated, number two, if you have a, if you're in a persistent vegetative state, or you have a terminal condition, or you have an end stage condition, are the three things they spell out. So you got to be incapacitated. You have to have one of those three ailments. And then third, you have to have your treating physician, a second consulting physician, provide that there's no reasonable medical probability. They have to provide a written opinion that, there's no medical probability that you're going to recover from the incapacity or the condition. Then in those instances that you want life-sustaining treatments or procedures withheld or withdrawn, and to be able to pass naturally. So that's a document that you say, if these things are going on, I don't want to be artificially kept alive on life support or what have you. And so a lot of people have a lot of different wishes than that.
Right.
And so
Very
that
personal.
document can be modified, and there's a lot of organizations. There's a form that we see that clients bring to my office a lot already completed called 5 Wishes.
I've seen that. Yeah.
Which is a
That's not a legal document, right?
it's not a
It's not legally binding.
well, it expresses your intentions,
Right.
And so if you have that document and you don't have anything conflicting with that, then that would carry the day in terms of what your intentions are. That the real goal is to in any of these situations, whether it be your will or your health, it is to clearly express your intentions and do so in a way that removes ambiguity and with respect to a will or a power of attorney, documents that need to be executed with certain formalities like witnesses and notaries, and
right.
like with a will. The witnesses have to watch the person signing the will sign the will. They have to be within eyeshot. The witnesses have to, everybody has to be around the same table essentially and watch each other sign for it to be technically, legally enforceable and a valid instrument. So making sure not only that you express your intentions clearly and try to avoid contradictory intentions from being, possibly interpreted following your death, and then doing it in a way that's legally enforceable is important. And that's where a lot of litigation comes out of is, what are the intentions? And we have, various pieces of evidence pointing to maybe contrary intentions, and that's where people can get, then in that case, a lot of times the only people that win are the lawyers, unfortunately.
Yeah. Well, earlier I talked about the 3 big pieces: the medical, the legal, and the financial. But at the end of the day, I really think the key to all this is the communication piece. Because with more communication, the more clear you are about your intentions or what you want, then the easier it is for your loved ones to know, in addition to the whatever legal documents have been drawn up, to actually know and feel good about what's happening. So
no, I think that's important, and I always suggest that we err on the side of transparency and those sorts of things, but not. Unfortunately, not all families are. Even not all parents maybe are feel comfortable being transparent with their children, or maybe there's some inter-family politics that create some issues there where transparency is not what you'd want it to be. And so anyway, we see all those situations, and but I do think that to the extent that your children are mature enough to understand things, and there aren't too many politics, that making them aware of what's going on.
Be nice to your kids.
Yeah. Well, making them aware of what's going on, and trying to have them. It probably promotes their own, if they know that their parents are getting their financial house in order and handling their things in a business-like fashion. That's probably a form of financial education for kids at a young age, and
I think that's a great idea.
And the last thing I'll say, just for the young folks out there, I have 3 children who are under the age of 5.
He has twins. He's probably pulling his hair out right now. We've got a lot going on.
Bedtime will be a little crazy tonight.
Yes.
But anyway, in the state of Florida, we have something called the designation of healthcare surrogate for minors, where the parents can name a family member or a friend, or multiple, primary with some backups, to be the healthcare surrogate for their minor children if they're unavailable to make those decisions. And I'm not talking about deceased or incapacitated. Incapacity would be one event, but let's say my wife and I take a trip go to the Bahamas, or take an international vacation. If we can coax our parents into coming and watching the kids for a few days. But you're unavailable because your cell phone doesn't work on the plane.
Or you've been drinking too many Goombay smashes. Just can't get back.
So if you have if you have that situation, you could name somebody who then, if the kid, if my daughter falls off the swing set and breaks her arm and has to have a procedure at Baptist or St. Vincent's or wherever, whoever's watching the child could, has this documentation to say, hey, I'm authorized to make medical decisions.
That's good to keep in mind for the grandparents, too.
That's right, yeah. Or if you have a nanny or whatever your situation is. But it's good. I always suggest to, anybody that's got minor children, I always just add that to the list of documents that we'll prepare as part of the estate planning package that we put together. And I always suggest that they, take it and put it on file at the school, just with the emergency contacts, and make sure that you just have all your bases covered, because a lot of times, we think about the will, but a lot of times, you're likely to have a situation where you need some help, but you're not dead, and so the power of attorney, the healthcare surrogate, and the healthcare surrogate for your minor children become important, and hopefully you never need them.
That's right, but you're prepared. And last question, and we'll be wrapping it up, but how often do you need to go back and look at these documents for updating? I mean, I think we came to you, and maybe my brother was the beneficiary of any. I mean, it had been a while.
Right.
I don't think it was that bad, but.
So I would say as a general rule, as a necessity, anytime you have a life-changing event. So if you have kids, if you add another child, it's important to do, you probably want to have, even though almost every will I draft, most wills that I see, prepared by reputable lawyers, and even the websites these days that spit out documents for a fraction of the cost of hiring a local professional, provide that, any child that's born, in the Florida statutes for that matter, any child that's born after the date of the will is automatically incorporated.
Oh, okay, so
but you want probably for emotional reasons, you don't want a child not listed in your will.
Johnny.
Exactly. So whenever you have an event in your life that changes things, so the addition of another child, and then I would say that, if you come into an inheritance, and your financial life changes, it may impact what you want to do estate planning wise.
And as you get older, is it every 5 year, or if nothing's changing, you're just getting older, racking up the years?
So I think what I see a lot of is as their children graduate from college and get out of high school, get into college, maybe they're going right into the workforce, not going to college, but there's a natural transition where your decision makers go from being your parents to being your children.
Right.
And, that can come at, earlier age for children. In some cases, they may be more mature than others. So it could be when the kids hit 20 or 22, they're perfectly capable of doing that. And maybe when they hit, in other instances, they could be 40 and still not be mature enough to handle those sorts of things. But whenever you have that transition, I think it's important to look at the documents. And I think, and then, there's no hard and fast rule, because if you have children that are, 30, 28 and 25, and they're all, college graduates, or, even if they're not college graduates, financially mature people, everybody gets along, you may go ahead and name your 3 children, and from oldest to youngest in succession as your backup trustees or personal representatives or what have you. And so in that instance, it may, divide everything to the spouse, divide equally between the kids. And if there's no need to, keep continuing trust going on for the protection of the children, or, if the assets are, below, the major tax thresholds, so that estate taxes are not much of a concern, then, then I just suggest, know what your documents say, have an idea of what your estate says, and then if that situation in terms of who's going to get what and who's going to be in charge of making sure that the beneficiaries get the assets in a timely fashion after you die, if those pieces are in place and there's no need to change them, then there's no need to change your document, because it'll work just as well now as it will 20 years from now. So as circumstances change, and then I would just say that whenever you, again, asset titling, and more importantly, a lot of these beneficiary designations. So people shift jobs so much. So old and cold 401ks,
Yeah, right.
IRAs. It's always good to try to maybe consolidate those and check on the beneficiary designations to ensure that, maybe you don't have a retirement account or a life insurance policy that leaves off one of your kids because you've had a new kid,
Right.
or leaves, and this is an important point, is that you don't have a life insurance policy that is going to pass to a minor child, in which case you have to do a similar process to a probate called a guardianship.
Okay.
And that can get a little dicey. So I think everybody should check their beneficiary designations and make sure that they comply with their estate planning intentions, what their documents say, number one, and don't leave. Let's not have any minor children inheriting IRAs or life insurance policies directly. And we can help with in a lot of I'm not the only one. There's a lot of good attorneys in town that people I'm sure work with, and these listeners who have worked with before. But checking the beneficiary designations and making sure that the assets are teed up to follow the instructions and the intentions expressed in your will.
Well, Kent, I'm going to rush home right now and go make sure that my beneficiaries are in line and I've got all that set up. But you may be seeing David and me in your office again real soon, so we can make sure we're squared away. But I really appreciate your time and for all of the expertise you shared with us tonight. And gosh, thanks for being with us.
Well, thank you for having me. It was a pleasure, and I hope somebody learned something from what I had to say. And
well, I know I did. So, and if anyone has any questions, Kent is available at Fraser and Fraser, PA. So give him a ring-a-ding. All right. Thanks so much, Kent.
Thank you.
Bye-bye. Thanks again to Kent Sausaman, an attorney with Fraser and Fraser Attorneys at Law, PA. It was a great talk, and you can look for it on our Instagram page, Facebook, YouTube, and on the new website, mygrandplans.com.